Yes, Mr. Parker.
My lady, my lords, my submissions deal with the ascertainment of custom, and I propose to structure them under 5 topics. First, to state the question and the 2 competing hypotheses in the case. Second, to summarise the 3 modes by which the content of custom may be proven in a court. Third, to introduce the House of Arikis and Kutunui papers and briefly outline their provenance and contents. Fourth, to develop submissions on why the papers are, we say, a final and conclusive custom or statement of custom under Article 66, capital A, sub 4 of the Constitution of the Cook Islands. And fifth, to analyse the content of custom applying the common law test based on the rule in Angu and Utter, and why we say that the papers must in any event carry the day in this case. So topic 1, the question and the competing hypotheses. The question simply is, under what circumstances can an adopted child, not of the blood, succeed to an adoptive parent's interests in native freehold land? The appellant's submission is that Mrs. Justice Isaac reached the correct interpretation of custom in his judgment, paragraphs 47 to 50, and that has 3 distinct elements. First, that a non-blood adoptee has no right to succeed, but may do so exceptionally where there is consensus in favour of it amongst the family. Second, that this means full acceptance amongst those who would otherwise have succeeded to the interest in question. And third, that opposition to the succession by those who would otherwise succeed to the relevant interest will negate the existence of full acceptance. Against us, the respondent's position is based on paragraphs 45 to 47 of the judgment of the Court of Appeal, and that is based on a test that they describe as maturation. Maturation occurs on the respondent's case where the deceased's family accepted that he or she would, and just quoting from the Court of Appeal, be treated in the same way as the deceased's natural children as regards property succession, which we say is a somewhat curious phrase because presumably in many cases there would be no natural children. That would be the point of the adoption. There we have it. And on the respondent's case, this must occur, if at all, during the life of the deceased. And finally, on the respondent's view, greater weight is to be given to the views of the immediate family, the nuclear family, over distant relatives. So that is how the battle lines are drawn on the issue of custom. The second topic, if I can briefly outline the 3 modes by which custom can be proved under the legal system of the Cook Islands. And as I understand, although contradicted later, this is all common ground. The first essential point is that custom is a question of fact, and there are 3 modes for proving it. The first manner is under Article 66, capital A, sub 4 of the Constitution, where there is a decision or opinion of the Arongamana. This is final and conclusive as to the content of custom. If that provision is inapplicable, the common law supplies 2 further modes of proof, and these are the 2 limbs of the rule in Angu and Utter. Limb 1 refers to proof of custom by calling witnesses acquainted with the native customs, so that is factual evidence. And Limb 2 applies where, but we say only where, the particular customs have, by frequent proof in the court, become so notorious that the courts will take judicial notice of them. So those are the 3 modes. Our case rests very heavily as to the content of custom on the papers from the House of Arikis and the Kutunui. So it may be convenient under topic 3 if I briefly introduce who they are and what the papers say. The House of Arikis. The Arikis are, of course, the high chiefs. The House is a national body in which the chiefs meet, and that is created by 1966 legislation. And as we've heard this morning, the House of Arikis is formally recognised in the Constitution. As to its relevant functions, these are prescribed in the Constitution and by ordinary legislation. But relevantly is the provisions or other provisions of the House of Arikis Act 1966. And I wonder if we could briefly turn that up. That is in the purple volume. The electronic page is 666, perhaps an ill omen. In the purple volume, it is at tab 6, page 46. House of Arikis Act 1966. In the second page of the Act, in section 2, we see interpretation, and the first term defined is ariki. Ariki means a person who has been invested with a title, rank, or office of ariki in accordance with ancient custom prevailing in each of the Cook Islands or in a group of 2 or more of the Cook Islands, ... So that's who the ariki are. And then as to their functions, if we could turn forward, please, to section 8 of the Act. In the electronic bundle, that's at page 672, right at the bottom, section 8 of the Act, page 52 in the hard copy, tab 6, page 52. And we see there section 8, and the chapeau reads, "The House shall have the following functions," and then over the page, at subparagraph 2, "It may of its own motion make recommendations to the Legislative Assembly upon any question affecting the customs or traditions of the Cook Islands, or of any of them, or of the inhabitants thereof, ... So there are 2 functions or 2 relevant points there. The first is that their functions prescribed by law necessarily involves expertise in ascertaining the content of custom. And the second point, which is relevant to a point I'm going to come to later, is that the Act expressly recognises a distinction between customs that operate at a national level and customs that operate at regional or even individual and sub-regional levels. So we have at least three different levels which customs operate. And that's relevant to an issue that I'll come to in a moment. The Kota Nui are a body created by an act, which is the House of Arikis Amendment Act of 1972, and that is in the same bundle at tab 10. The electronic reference is page 700. 700. And if my lady and my lords have the page, one sees just below the line, 1972, number 7, this is an act to amend the House of Arikis Act 1966 by adding a new part providing for meetings of the Kavana, Mata Aipo and Rangatira. Section 21, we then have, this is at page 79 in the bundle. Section 21, we then have the interpretation. Kavana means a person entitled to hold office as a Kavana in accordance with custom of the Cook Islands, and then mutatis mutandis for Mata Aipo and Rangatira. Over the page, section 22, the Kavana, Mata Aipo and Rangatira of the Cook Islands may meet together at such times and at such places as they shall determine, and when so meeting together, they shall be known as the Kota Nui. And then, quite important, section 23, functions of the Kota Nui, subsection 1, the Kota Nui may discuss and make recommendations or resolutions on any matter relating to the customs or traditions of the Cook Islands. So again, this is a body with an express function that presupposes expertise, unsurprisingly given its membership in custom. I will also draw your attention just to one more feature of this Act. Section 24.2, procedure at meetings, provides that any Ariki shall be permitted to attend and speak, but shall not be entitled to vote at any meeting of the Kota Nui. So there's an ex officio attendance right and speaking right on the part of also the Arikis. So that's who the House of Arikis and the Kota Nui are and what their functions are. As to the papers themselves, they are recommendations, or they take the form of recommendations for legislative reform. They contain a detailed exposition as to the existing state of custom, which is, of course, necessary as a backcloth for any proposal for reform. And as is recorded in the 1977 paper of the House of Arikis, which we've set out in our case, the papers were the result of 3 years' strenuous research by a select committee of the Kota Nui who delved into many historical documents and papers. So that's the nature and provenance of the papers. As to the content of the papers, the relevant custom, we've set out in our printed case at some length the relevant passages. And unless it's going to assist, I don't propose to read them again to the board, but simply to list the principal features that we identify from the papers that make up the relevant content of the custom. And the principal features are these.
Can you give us the page references to the actual documents, just for our notes, please?
Of course. So in the printed case...
No, the actual documents.
Yes, I can, yes. The actual documents are in bundle 2, behind tabs 19 to 23, which on the electronic version begins from page 269.
269.
269.
Thank you.
And the papers go from there.
And the hard copy version?
The hard copy version, volume 2 of the record, tab, what we're calling South Pacific Blue, volume 2.
Yes. Page?
Tab 19,
Tab 19.
page 261. And then
the collection of all this in your case starts at which paragraph?
that starts at paragraph 100.
Right.
And the case, the electronic volume for where those paragraphs are set out in the case is at page 528.
Yeah.
That's our case where we set out the relevant paragraphs. The principal features, then, to be extracted from the papers and as set out in those quotations in our case are these. First, that land belongs to the family and tribe. Second, that succession rights flow from a blood connection to the ancestral owner. Third, that custom only recognises blood adoptions and that non-blood adoptions are a European import. And finally, and we say directly on point, and I'll just read the actual paragraph out. It says, any child, this is in the Kotanui paper, record bundle 2, tab 20, page 280, which is 288 in the electronic version, under letter B. It says, any child not adopted in accordance with Indigenous custom may claim the right of succession to traditional land, but subject to the approval of the descendants of the common ancestor, and upon such terms and conditions as the descendants of the common ancestor may impose. So that's what we say is the key crystallisation of the custom, which decisively resolves the case in our client's favour. And the respondents in their written submissions quite fairly accept that if the papers do indeed state the correct custom, that is in effect fatal to the respondent's application. So I now come on to topic 4.
This is page 280, you said. Yes, I just want to understand, are we to take it from your description, particularly point 3, custom only recognises blood adoption? Was it the case before the 1915 Act brought what you might call European adoption by registration into the law of the Cook Islands? Was it the case that the only adoptions that were affected were blood adoptions, i.e. someone adopting his nephew or niece or whatever?
Well, that is in substance what the Kotanui report says.
Yes, and that's your position?
There isn't any contradictory evidence. I'm certainly not in a position to offer any other statement other than the Kotanui say that was the position, having studied it.
I thought there was some statement from 1894.
Yes.
I thought which...
Yes, there was.
...dealt with adopted children as if they were non-blood.
Yes, certainly syntactically it says that, but it's not entirely clear from the 1894 statement. This is the point we make in our supplemental case. The other side relies heavily on the 1894 statement. It has several perhaps difficult points with it. The Kotanui ultimately look at the 1894 statement and say, well, in principle, yes, but it's too general and it requires clarification. And they go on and give the clarification. And they explain that at least on the syntax, there's nothing in the statement that says, well, there are non-blood adoptions in Cook Islands custom. It merely appears on its face to draw a distinction. The 1894 declaration between blood adoptions and non-blood, the blood children and
Where do they
adopted
deal
children.
with that, the Kotanui?
The Kota Nui, I do apologise. That is page 290, my note says.
Electronic 290.
Electronic 290, and in the hard copy volume, that should be, 298 in the electronic version and 290 in the hard copy.
298.
290. Oh yes, page 290 in the hard copy, 298 electronic version, the third full paragraph. The House of Arikis, does my lord have the page?
Yeah.
Yes.
Yes. The House of Arikis debated the paper and submits this document based mainly on the paper for consideration by the Legislative Assembly. The content of the paper is founded on the declaration of the Cook Islands Federal Parliament in 1894, but it is felt that the declaration is too general and therefore requires clarification and redefining. We know nothing about the 1894 statement except what it says on its face, and that it was prepared ultimately by the British resident, Mr. Moss. We don't know about his expertise, we don't know how it was drawn together. And in our submission, when we have simply the bland 1894 statement and a subsequent statement saying, well, look, it is much too general, on its face, the 1894 statement appears to imply that all adoptions are non-blood adoptions. It draws the distinction between children of the blood and adopted children, which obviously can't be right when the principle is at least that the majority or most adoptions are adoptions of the blood. So we submit that 1894 statement, which has been expressly repudiated by the Kota Nui, at least in relation to its generality, really can't carry the day. And it's not clear what its provenance is or why, when we have an expert body who says, well, this is too general and here's the real custom, which is what I've read to you.
If your case is that the only native customary adoption is blood adoption, and that non-blood adoption is purely a European import, how do you get out of anything a custom about the circumstances in which a non-blood adoptee succeeds to native land?
Yes. Earlier on, my Lady Hale asked the question, is the custom immutable or is there some adaptation to the circumstances?
That's what I was asking.
Yes, and we anticipate that the paragraph I read to you from the Kota Nui, which says that the accession may be possible subject to the approval of the descendants of the common ancestor, may well come within that category. But that's a distinct statement from the people whose expertise we rely upon about what the content of the custom is. So we're certainly not going to say that some more extreme version ought to be propounded or a more restrictive version ought to be propounded. But the document says both things at once, and so we assume that is at least some concession to modernity and to new circumstances. But
does that tally with Section 465 of the Cook Islands Act 1915, which is in purple volume, hard copy, page 30? Because if the only form of native customary adoption was blood adoption, then there didn't need to be any approval or acceptance by the family. Blood spoke for itself. And the section says, an order for adoption shall have in respect to succession, reading short, the same operation in effect as that which is attributed by native custom to adoption by native custom.
yes.
I mean, how has custom developed to contradict that? 30.
And how can it, bearing in mind the constitutional provision that custom is not to conflict with the statute?
Yes.
Our submission in respect to that section is that its purpose and effect is to have us look at custom and determine what the content of the custom is. We can't advance some other submission other than the factual evidence of the custom that we have before us. We say that that is the document provided by the Kota Nui. There's nothing necessarily implicit in our submission in section 465 or in the content of the constitutional provision that we'll come to in a moment, which suggests that content of custom can't adapt to some extent to modern circumstances.
But has adoption by native custom, i.e. blood adoption, has it adapted to impose a further requirement on top of blood to require acceptance by the family by consensus? I presume not.
If the answer is, well, the full original version of custom as it previously obtained still subsists, in which there is no possibility of a non-blood adoptee succeeding, then that would of course be entirely also detrimental, fatal to the respondent's case. The concession that's been...
I mean, looking at the words of 465, the formal adoption shall have the same operation and effect as that which is attributed by native custom to adoption by native custom. I mean, that might call into question the validity of any post-1915 customary development.
If its consequence was to deprive someone who is a statutory adoptee of the same benefits as a customary adoptee from adoption.
We submit that the consistent interpretation of this provision, there's a decision on it, a good description of how the provision operates in Power-E number 2, which I'll turn up in a moment.
Yeah.
But our submission is that the consistent interpretation, correct interpretation, is that the purpose of the provision is not to upset or amend custom, not to put a non-blood adoptee in the same position as if they were a child of the blood, but simply to look to refer us to the content of native custom to determine the question of succession.
I think it may be implicit in Lord Hodge's question that attributed by native custom to adoption by native custom is a reference to the custom as it stood in 1915, whereas I understand the essence of your submission to be that it's actually a reference to native custom as it is from time to time, so that if after 1915, possibly under European influence, possibly for other reasons, the custom is modified, it is the modified version which would apply.
It is the modified version that applies.
That's your case, isn't it?
Well, yes, that's how we reconcile the parts of the Cotonui report, which appear to show at least some temperance in the stricture of the rule in later times. But if that submission ultimately is wrong, and that one assumes that the more refined version that's been put in the paragraph I read to you is an illegitimate, even if the custom has developed, is an illegitimate application of section 465, then one would refer back to the strict former custom, and then the position would simply be that there is no provision under custom for native adoption. That's the stricter earlier hypothesis. I only suggested that the paragraph I referred to in the Cotonui report might be a modification.
So if it's frozen, it's frozen to your advantage.
Frozen to our advantage. Could I perhaps turn up just to see how the Court of Appeal in Power-E looked at that section, how they interpreted it? That's Power-E number 2. In the electronic bundle, that's page 888.
Sorry, 800 and...
888.
888.
888.
Tab?
Which is tab 28 in the volume of authorities. And it's in the hard copy bundle, page 257.
Now mine's popped up on page 3. Is that right, the case?
That's page 3 is correct. Hopefully it will say 257 in the bottom right corner of my list, but yes. So the last full paragraph, it says, so through an order for adoption, so though an order for adoption has in respect of succession to the estate of any native in the Cook Islands the same operation and effect as that which is attributed by native custom to adoption by native custom, see the section of the Act, and whereas native custom as a rule provides for a child to succeed to the land interest of both his natural parents, nevertheless that custom is somewhat changed when the rights of an adopted child to succeed to his adoptive parents are considered. What is generally accepted as the leading discussion of the custom as it then applied is to be found in the judgment of Chief Judge Morgan in the Land Court, and there's reference to Emma. And then the first full paragraph at A, below the paragraph, the first subparagraph at A, as the adoption order itself does not confer upon the adopted child an unqualified right to succeed, the court is required to determine the issue in accordance with native custom. So a reading Section 465 cannot be read to put a non-blood adoptive child in the same position as an adopted
Certainly
child.
the case law by the local court who know the customs best that doesn't seem to take the meaning of Section 465 that I was putting to you. I fully accept that.
Lord, and so we say, as with respect, my Lord Sumption put to me, if the custom is frozen back in time, it's certainly going to be more advantageous to our clients and not less when the section is applied as such.
I'm not sure about that, but in any event, the local jurisprudence has not gone down that road.
Yes, for a significant number of years, since more than 100 years since the enactment of the provision. So that brings me to the fourth head of my submissions, which is why...
Just before you go, he's affirming, isn't he, the analysis in Emma number 1?
I take him to be affirming Emma in that case, yes.
And that's the one principally relied upon by the Court of Appeal?
That's correct, yes. Although there are elements of both decisions that are significantly double-edged for both parties. When I come to the second limb of the ruling, anger and utter, I will suggest that the court may feel, reading through the authorities, that none of them, that they're certainly not clear and consistent, and some of them mutually and internally inconsistent. We're far from a situation where one can read the line of judgments and say, we have a line of judgments themselves based on findings of fact on proper evidence, which are clear and consistent, of which judicial notice can be taken. The topic I now want to come to is Article 66, capital A, subsection 4 of the Constitution, and why it is we say that the papers are a binding opinion of the Arongamana under that section. This is the first case in which a court has been asked to consider whether an opinion of the House of Arikis and the Kotonui could fall within that provision. The appellants, of course, say it can, and the respondents say it cannot. If I may, I will outline first why we say the opinion comes within the section, and then deal in turn with each of the three objections that the respondent puts forward in relation to our analysis. Could we begin, please, by looking at the text of that section. That is in the purple volume behind tab 1, page 13, and the electronic reference is page 630. Subsection 4 reads, for the purposes of this Constitution, the opinion of the Arongamana of the island or vaka to which a custom, tradition or value relates, as to matters relating to and concerning custom, tradition, usage, or the existence, extent, or application of custom, shall be final and conclusive, and shall not be questioned in any court of law. Sound like famous anisminic words. The Court of Appeal found in its judgment, that's paragraph 38-39, that this provision contained what it called lacunae. And the 4 lacunae it identified were, 1, that there is no definition given in the Constitution of Arongamana. 2, there is no indication of how the Arongamana is or are to be constituted. 3, it is unclear who is to verify its composition. And 4, the mechanism by which the Arongamana is to express its opinions is not stated. And it therefore concluded that it would, quote in paragraph 39, have to look elsewhere for evidence of custom. We submit that each of the 4 supposed lacunae are soluble, at least in this case, and that the papers are recognisable as an opinion or decision of the Arongamana within the provision. There is a significant amount now of common ground between the parties in the approach to that provision of the Constitution. The first element of the common ground is as to its effect. There is no dispute that once there is a decision of the Arongamana, that is conclusive and cannot be displaced by any other form of evidence, and that the court's role thereafter, once such a decision or opinion exists, is to test whether there is incompatibility with statute and to apply the custom stated to the facts. And also, very importantly, the second point of common ground, the parties are ad idem as to the identity of the Arongamana. And the agreed definition, and I'll show your ladyship and your lordships where it comes from in a moment, the agreed definition is this, is persons holding traditional titles in accordance with native custom and usage. We can see that in the first instance from the parliamentary materials. We have set out in paragraph 82 of our printed case an excerpt from Hansard, which is from the Minister for Outer Islands, the Honourable Mr. Pukino, and he there explains that the Orongomana, well, he's rather dismissive of the idea that any Cook Islander might ask such a foolish question as who the Orongomana are. I have to confess that would apply to me equally. He says that the Orongomana are the people who have inherited titles from their forefathers. But we agree with our learned friends that perhaps the better formulation is those holding traditional titles in accordance with native custom. Now, there are two items of ordinary legislation that strongly support that conclusion. One of them predates the amendment and the other postdates it. They are set out most conveniently together in the first decision on this subject in Hunt and de Miguel. That is in the electronic bundle, page 938.
So sorry?
938.
Thank you.
In the purple bundle, that is then behind tab 34, second to last tab, at page 346. Yes, I certainly hope it is. Yes. Paragraph 10. This is paragraph
You've got
10.
the wrong reference.
I apologise.
I'm very sorry.
That's the incorrect electronic reference, is it? That should,
Well, I probably wrote down the wrong one.
983.
983.
Ah, I thought you said 938.
Oh,
That's
I
exactly
probably
what,
did.
that's what I wrote down too.
I've two witnesses against one. It's my dyslexia.
I concur. 3 witnesses.
That's the majority of the bench.
983.
So paragraph 10 of Hunt and de Miguel. Do everybody now have that open?
Yes.
Thank you. Meaning of Orongomana. And we see that there are two sections of ordinary legislation set out here. The first is section 2 of the Rarotonga Local Government Act. I've noticed, having caused a search to be done, that there is one typo in it, and I've got the original copy of the legislation, and I'll just point out where that is. In the first line of the 1988 Act, it says that the Orongomana include those invested with the title. That should be those persons invested with a title. And if perhaps at a convenient moment, I can hand up an original copy of the legislation, which is...
We'll take your word for it.
Thank you very much. Orongomana include those persons invested with the title in accordance with the native custom and usage of the part of Rarotonga from which the title is derived, and which titles is recognised by such native custom and usage as entitling the holder to be a member of the Orongomana in the Kutanui of the Cook Islands. So that's the express legislative connection between those holding inherited titles, the Orongomana, and membership in the Kutanui. So we place significant weight on that. And then in the Environment Act, one sees an Orongomana includes those persons invested with a title in accordance with native custom and usage of the islands of the Cook Islands from which that title is derived, and which title is recognised by such native custom and usage as entitling the holder to be a member of the Orongomana of the Cook Islands. While we have these sections open, I just make one contrast, because it's one of the points taken against us is that the Orongomana must be the Orongomana of a single island or vaka. And I'll come to that in a moment. But what one sees is that in the Rarotonga Local Government Act, in the second last line, that refers to the Orongomana of Rarotonga. But in the Environment Act, it refers in the last line a member of the Orongomana of the Cook Islands. So one sees quite distinctly, as with the custom, that the notion of Orongomana exists at least two levels. One is for the island or vaka, in that case it's Rarotonga, so 3 vaka, and the other is of the Cook Islands. And so we submit that is very important when it comes to considering whether a national body can or cannot constitute the Orongomana. So standing back, having looked at those provisions, once it's seen that the Orongomana are those holding customary titles, it is entirely logical in our submission that a decision of the Orongomana should be capable of embracing concurrent decisions or concurrent statement of the House of Arikis and the Kutanui. They are bodies of assembly created by law for those holding customary titles. Their functions, prescribed by law, include making recommendations on any question affecting the customs or traditions of the Cook Islands, or of any of them, or of their inhabitants. and those functions presuppose necessarily authoritative knowledge about the contents of Cook Islands Maori custom. As to the papers themselves, they are the product of the exercise of those functions. They are clear, concurrent statements expressed in the form of an opinion as to the content of custom, and the appellants submit that on that basis they fall within Article 66, capital A4, as a decision of the Rongamana. Now, as against that, our learned friends take 3 points against us. The first is, it is said to, that analysis is said to ignore the words of the island or vaka in Article 66, capital A, sub 4. The second argument is that the provisions governing membership of the House of Arikis and Putanui are such that they impose limitations precluding them from constituting the Rongamana. And the third point against us, it is said that our construction involves those bodies exercising decisive functions about the content of custom, whereas other aspects of the law refer to them having only a recommendatory function. We respectfully say that none of those analyses withstands a thorough scrutiny and that they must fail. As to the first, this is the point, the national or local point, the reference to the words, the Rongamana of the island or vaka to which a custom, tradition or usage relates. Our learned friends, the effect of their submission is that an opinion could only be admissible as an opinion of the Rongamana if it is the Rongamana of one single island or vaka, being that with which the facts of the case are concerned. We respectfully say that that submission is defeated by legislation, by case law, and also by common sense, although possibly not in that order. As to the legislation, citing Lord Reid writing as traditionally, the relevant legislation expressly contemplates that some customs are national, some are regional, and some are sub-regional. I showed the board earlier section 8, subsection 2 of the House of Arikis Act, and that refers to the customs, traditions and usages of the Cook Islands, or any of them, or their inhabitants. Moreover, the legislation that we just looked at, the Rarotonga Local Government Act, talks about a regional Rongamana of Rarotonga, and the Environment Act speaks of the Rongamana of the Cook Islands. And we submit, therefore, reading the legislation together in harmony with the constitutional provision, one has to look at the particular custom and say, is this a national or a custom that covers the whole of the Cook Islands, or is this a limited custom to a particular island or vaka, or several of them, to determine who can authoritatively pronounce on its contents? And that submission, we say, is supported by the decision of Dame Judith Potter in Framheim and Attorney General. I would like to go through that in just a little detail if I can. The board can find that in the electronic bundle at page 1038, 1038. And in the hard copy, that's in the purple volume, tab 35, from page 400. It's the last case in the purple volume. And could I ask my lady and my lords please to come to paragraph 3 of the judgment, which simply sets out what the issue is. I should perhaps preface this by saying this judgment is recent and I understand it is currently under appeal and has been argued, and our learned friend, I gather, Mr. Hikaka, has some skin in the game as counsel for the appellant. So that's the current status of the case. So paragraph 3. Until recently, purse seine fishing had not regularly occurred in the Cook Islands waters. However, between 2013 and 16, the Cook Islands government made a series of decisions increasing the potential volume of purse seine fishing catches within the Cook Islands EEZ. The plaintiffs now seek judicial review of those decisions. In short, they say that the respondent's decision-making process did not comply with the Marine Resources Act and did not comply, presumably that should be with customary law, as said to be required by Article 66A, subsection 3 of the Constitution. And then at paragraph 25 of the judgment, we have the grounds of review. The relevant ground is ground 3, which is paragraph 25C. C for cat. The decisions are allegedly in breach of both the Marine Resources Act and Article 66A3 of the Cook Islands Constitution, because the Oranga were not consulted during the decision-making process. Article 66A, subsection 3, provides that traditional Maori custom is part of Cook Islands law until an Act of Parliament provides otherwise. Now, Browne 3 picks up from paragraph 110 in the judgment 110.
Sorry, paragraph?
110, 110. Page 438 in the hard volume. And it says this: the third cause of action is brought by Mr. Framheim alone. In short, he says the Minister and the Secretary have a duty to consult the Oranga before promulgating the regulations and the plan, and before initiating the partnership agreement and international protocol, but did not do so. Those are agreements with the European Union to allow EU flag vessels to engage in purse seine fishing in the Cook Islands EEZ. The duty is said to arise from custom, which applies via Article 66A3 of the Constitution, and then we see the provision is set out. And then there's a preliminary issue taken at paragraph 113. It says there are two preliminary issues. The first is the definition of Oranga, and the second is Mr. Framheim's standing to bring the cause of action. And at 114, the Constitution does not define the term Oranga. Parliamentary discussion during the passage of the relevant constitutional amendments indicates that some considered the term to be sufficiently well known by Cook Islanders as to not require definition. And then there's a citation, paragraph 78, footnote 78 from Hansard. We assume that's page 1958, not 1985, which is what we referred to. 115, the Court of Appeal considered the meaning of Oranga in Hunt and de Miguel. The case will be discussed in some detail below. For present purposes, it's sufficient to record that the court noted Oranga might be broadly defined as a group of traditional leaders from a particular district. In attempting to pin down a more specific definition, the court took guidance from two ordinary statutes, and we have seen those. And then at paragraph 117, we see the citation from Hunt and de Miguel. And at 118, Her Ladyship says that she notes the regret expressed by the court in Hunt and de Miguel and the plea for enlightenment that the Court of Appeal in the present case made. Over the page, please, to 121. Para 121. However, during an interlocutory hearing for these proceedings, Western CJ raised concerns over Mr. Framheim's standing to bring the third cause of action on behalf of the Oranga on a national level. And at 17, the Chief Justice had said this: it seems to me that the applicant's challenge in this case proceeds on a national basis. If that is so, there must be an argument that the Oranga should be thought of in national terms rather than simply regional. The Oranga, as currently cited in the Statement of Claim, is that of Te Ao o Tonga, being one of the three Vaka of Rarotonga. Mr. Framheim's affidavit, however, does range wider than that and includes, for example, the Oranga of Pukapuka. Ultimately, of course, this will be a matter for the applicants and their advisors, but it seems to me that the applicants need to be thinking about the Oranga in a national sense. If that is so, the question then to be considered is how the views of the Oranga are to be assembled and how they're to be communicated to the court. At para 122, we see the efforts then that Mr. Framheim and his poor legal advisors had to take to try to secure affirmation or affidavit evidence from a wide range of people claiming to be the Oranga. And we see then at 129 how Dame Judith Potter dealt with the submission. She said the three statements by claimed Oranga from across the Cook Islands, 129, have been adduced as evidence to confirm the identities of members of the Oranga and to indicate the Oranga opinion as to custom, including surrounding seafood, kaimoana. There is a single statement representing the Oranga of Te Ao o Tonga, Takitumu, and Puekura, the three Vaka of Rarotonga. There are two separate statements from the Oranga of Aitutaki and Atiu, and according to Mr. Hikaka, each statement has been widely signed. And then we see that there have been signatures of many of them, but not by all the people who say that they are the Oranga. Over the page at 131, which I will not read, but just for your note, that is the submission from Mr. Hikaka. He says the affirmation evidence, the affidavit evidence, was sufficient to amount to proof of who the Oranga are and their views. And then the finding is at para 141, where the judge says, I share the Court of Appeal's concerns noted above about the meaning of Wrongamana, the composition and verification of its members, and the mechanism by which the Wrongamana are to express decisions or opinions as to custom. So despite the great lengths to which Mr. Framheim and his legal team have gone to avoid these problems, they continue to loom in the present case. For example, other than the signatories' own claims, I have no evidence that the signatories are actually the Wrongamana of the Waka or island they claim to represent, and I have no evidence that the list of the Wrongamana in the statements are complete or exhaustive. Further difficulty is caused by the fact that only a majority of the Wrongamana of Aitutaki have signed the statement, it being unclear whether an opinion by the majority of the Wrongamana is sufficient to comprise a conclusive opinion in terms of Article 66A4. So the points that we take from that are, first of all, one does and should look at the custom at both a national level, if it is a national custom, or a regional level, if it's a regional custom, or even an individual family level, if that is what the custom says. And we submit that respect...
But if you say if that is what the custom says, aren't you going round in a circle? I thought you go to the Wrongamana to find out bindingly what a custom is. A custom might be national, regional, or local.
Yes.
But how can you start with an assumption that it's one of those three for the purpose of defining the Wrongamana, which either tells you or doesn't tell you what it says?
That could be difficult in a case where there are contradictory claims. In the present case, there's no dispute whatsoever that the custom is one that operates at a national level. So, for example, our learned friend's submission is put on the basis of two judgments of the court, the Emma case and Pauri'i number 2. It's not been suggested that they are relevant because they are judgments relating to land in the same island or Waka. It may be that, my lord, in a different case where there was a contest about whether it was a regional or a national custom. But nonetheless, that's the approach that the court took in Framheim, and that was, of course, a case concerning the whole of the exclusive economic zone of the Cook Islands. So we say that it may depend on the facts, and one could run into circuitousness if there was a contest about it. But in this case, we simply have no such contest, and nobody has suggested that one can identify in a concrete way a particular custom of a given island or Waka as it applies in this case. And we've endeavoured to show in our supplemental case that, in fact, the custom in this case really is common to the whole of the Cook Islands. And we make the point that the Kotonui papers and the House of Riki's papers, and I'll just give the paragraph references, this is paragraph 22 to 24 of our supplemental case. They very carefully distinguish between areas where the custom is specific to a given region or where there is variance in the custom to a given region, and there is no caveat or cutting down of the generality of the custom in relation to succession, in relation to adoption of or adopted non-blood children. So we say that, read in context of the report, it's clear that this is being presented as a custom that is universal across the Cook Islands without regional variation. And in that context, it is perfectly proper and appropriate that a national body prescribed by law with proper legal proceedings about how decisions are adopted and how opinions are stated, and they have been adopted following those procedures, does constitute a decision of the Wrongamana for the purposes of the case. The second objection that is taken against us can be dealt with very shortly. It's said that...
How do you get over the linguistic point, though? Because, under Section 66, it ought to be the Wrongamana of the island of Waka.
Yes.
And it does appear, I think, that there are individual Wrongamana of each island.
Yes. So our submission...
You skip up to the national level, what, because of that dictum saying it was more appropriate to look at the national level? Or?
Well, we submit that the contrary hypothesis would be an unusual reading of the constitutional provision. It would say that there was a definitive power to pronounce only on some kinds of custom, only regional customs, and only in relation to regional Wrongamana.
Well, it needn't be a regional custom. I mean, if the Wrongamana of a particular district says the custom here is X, and by the way, it's the same all around the Cook Islands, it would still be a binding determination of the Wrongamana of that district for any dispute about the applicability of the custom to that district.
I would accept that, But the real question is, does one have to read only in the singular? Because the conditioning words, my friend's submission is, we look at the Orongamana of the particular island or Vaka because those are the places to which the facts of the case relate. Whereas what the language of the section of the article says is that it is the island or Vaka to which the custom traditional value relates. Now, in our submission, if the custom traditional value relates to more than one island or Vaka, or to all of them, then that must be the Orongamana to whom one looks. It isn't. Yeah. It's not a litigious focus provision that says, well, if you've got facts that lands on this island, go and ask them. One focuses on the custom. And so if it is right that the custom is truly a national custom and it relates to more than one island or Vaka, it would in our submission be irrational to read the use of the singular as not including the plural in that context.
Well, you've only got about 5 minutes left. So.
I'm going to race ahead. We've set out in writing, I perhaps won't deal with, in oral submissions, the supposed mismatch between the membership of Orongamana and the House of Arikis, and likewise the objection that because the other functions are recommendatory and these are decisive functions, that is inconsistent. We say that is a non sequitur. The last point is about ascertaining the content of custom at common law. And it's common ground, as I've said, that one looks at the two limbs of angu and utter. We say that this is a very clear case in which there is powerful factual evidence under limb 1 of angu and utter, evidence of fact. And can I give just one reference to the board in relation to the permissive and flexible approach to evidence? If the board looks at the decision, I'm not going to turn it up, Hunt and de Miguel, at 162 to 164, the electronic bundle reference is 1031, hard copy, purple, tab 34, page 394. And you will see there a reference to the New Zealand decisions describing the flexible and permissive approach to evidence. So under the first limb, we say that there are 6 very good reasons why the papers should be considered to be conclusive evidence of the custom. The first is that the members of the House of Arikis and Kotonui are themselves leaders under traditional law. They can be expected to have intricate knowledge of the customs and usages. Second, the authority of the House of Arikis and Kotonui in relation to Maori customs and traditions is recognised, in fact prescribed by law. Third, even if the House of Arikis and the Kotonui are not wholly coextensive with the Orongamana, as has been submitted, and of course we would only get this far if we failed under the constitutional limb, their membership is clearly very closely coextensive, and that underlines their authority. Fourth, as seen from the 1977 papers, they were produced following 3 years of sustained study based on historical documents and other evidence. Fifth, the express purpose of the papers was to spell out what the content of the custom was. And sixth, the relevant pronouncements are clear and consistent and entirely decisive of the present case. The final point that I can deal with in about 3 minutes and 42 seconds is simply the second limb of angu and utter, and that is where our learned friends attempt to take the case entirely home. We begin by observing that there is no factual evidence before the board, and there was no factual evidence before either court below, that maturation is the test. There's no evidence of that as a fact. And so the entirety of the respondent's submission must be based on the decisions coming out of the Cook Islands. And the question is whether, and we say the answer is no, whether the necessary preconditions for the engagement of the second limb of angu and utter are satisfied. We say, first of all, none of the decisions cited are themselves based upon factual evidence. The only exception is Short and Whittaker, which is based on the papers and is entirely against our learned friends for the respondents. None of the other decisions are based on factual evidence. And in fact, the Court of Appeal in the Emma decision, which our learned friends prenatal very heavily, specifically says that there was no evidence as to the custom called. And second, as has been described earlier, the line of cases is inconsistent and does not clearly elucidate the custom contended for by our learned friends. What we submit the cases show is not a notorious fact, but a notorious controversy. And no doubt in our submission, the inconsistency in the cases and difficulty in reconciling them flows precisely from the fact that they are not based on proper evidence, factual evidence as to the custom. And so we therefore submit that Mr. Justice Isaac is correct to hold in his paragraph 42 that the Cook Islands decisions have to be looked at in light of the papers which carry the real weight and not the other way around. So unless the board had any further questions for either myself or Dr. McCoy in the remaining small amount of time, those are our submissions.
Well, you timed them almost perfectly. Very well
much.
done, Mr. Parker. Mr. Hickey.
My Ladyship, my Lordships, I propose to probably address this in two parts, assuming that the board doesn't want to hear from me on the question of service. I will go through and lead the board through the cases, if it pleases, to actually show the custom we say we are dealing about, with particular reference to my Lord Sumption's question as to what do the cases actually say about maturity or succession. My learned friend and I disagree on that. We say that the cases consistently show that the appropriate test is succession, and we say the cases do not show unanimity at all. Before doing that, I might just clear up two quick factual points. And one is the claim from my learned friends that succession only occurs from the date of a succession order, so that there's this timing issue from the Court of Appeals decision. Now, we say the actual correct position is that the succession order is expressed to take effect from the date of death, and I'll refer your Lordships and Ladyship to volume in electronic text, page 407 through 408, and in non-electronic form, volume 3, tab 39, page 399. And that is an example of a title record. There is the list of owners, and just to clarify, the A means where it says FA, that's female adult, not alive. A dead person can't succeed. What we have is, and that's seen by M11, F10, F9 down the bottom, which refer to ages, so A is adult. Over the page, on page 400, hard copy, 408, electronic, about the middle of the page, one sees the succession order vesting the interest of Munokoa Browne as from the year 1960 in the following persons. And you'll see at the top of that, the succession order was actually made on the 8th of November 1970.
And do we know that's the date of her death?
I don't have
Is
any
that just an
evidence
assumption?
of that. That is an assumption, sir, but we would submit there's no other reason to backdate to that death, to that date. Sections 451 and 452 of the Cook Islands Act merely provide that you can't launch a proceeding where you haven't yet succeeded, which makes sense, standing to do so. The other, just quick note is, and I don't mean to undermine His Honour Justice Isaac's experience at all, but the regime in New Zealand under Te Ture Whenua Māori Act 1993, especially on the question of adoption, is far from coextensive with that of the Cook Islands. Under Te Ture Whenua Māori Act, any legally adopted child can succeed as of right. They don't need any blood connection. and indeed any whāngai child, which is a child adopted according to tikanga Māori, similar to an āngai adoption, an adoption at native custom here, can also succeed if the Māori Land Court allows it. So it's almost the opposite of the Cook Islands in that respect.
So you're suggesting that what happens in New Zealand is not necessarily very helpful in deciding what happens on the Cook Islands?
Yes, lady. Also, in New Zealand, there is a tendency where there is a question about adoption of or succession from a whāngai child. Often the Māori Land Court will commission and call specific expert evidence about what the effect of whāngai is related to succession in the particular rohi, or hapu usually, of the adoptee. So we say that recognition of the custom that non-blood adoptees can succeed to the land of adopting parents if the adoption matures is long-standing and properly based. And if I may begin at the Mataroa Iti case, which electronically is at page 836, and old school manner at at the Lavender volume, tab 19, page 211. This case predates the Emma decision, but is another decision that illustrates that a non-blood adoptee could succeed. We can see that it's a non-blood adoptee at the bottom of page 210, non-electronically. I don't know of any relationship between Kiu Mataroa and Mataroa Iti.
Sorry, I'm lost. You said E836.
Yes.
Bottom of 210.
So that would be 835, bottom of 835. So.
Yeah. And where is the quotation?
The quotation is the very last two lines.
Oh, I've got it. Yes.
But notwithstanding that lack of any connection, the adoption was allowed, and we say it must be remembered that all of these, the succession was allowed, not the adoption.
Yes, succession.
All of these successions have been allowed as being a matter of custom, because that is the only way one can succeed in the Cook Islands, succeed to native freehold land. The next place we turn is the Emma decision, Rimotoa, and that is electronically begins at page 850 and in hard copy at the same volume, tab 22, page 222. This is the foundational statement that has been...
Can I just ask, what did you get out of the first case?
We get that a non-blood adoptee has been permitted to succeed as a matter of custom.
Notwithstanding that these were contentious proceedings.
Notwithstanding that.
So therefore not unanimity.
Yes.
Well, I thought, yes.
It doesn't tell you why.
No.
No.
But I thought that there was no general decision in that case.
There is a succession to two lands. The rest of the lands are not succeeded to. Part of the...
I mean, the argument was that the lands into which succession was ordered it was agreed before the adoption was registered, so that the family all agreed, and the other ones, the judge, I thought, said they should be dealt with on their own merits, but it wasn't out of place to ask why was he put into some land and not in others. The explanation might well be found in Rangi Xapi's evidence above, and that was the evidence which explained that there had been a specific agreement in respect to the lands into which he was put by this order. So I wasn't sure this case was very helpful reading it to you. I mean, it doesn't seem...
Well, it's... the
evidence of Rangi Xapi was that there was agreement by the family, wasn't it? In particular, Xapi at first refused, but on the second occasion he agreed on condition that Mataura Iti should come into one land only. Then somebody else agreed, and so the child was registered. That land was the two pieces. Those are the only lands in which he could have shares. That was agreed before the adoption was registered. And those are the only lands into which he was put by this order. Rupanui and Vataputu.
Yes, I might be reading it slightly differently to your lordship. I'm also looking at the...
I read it, as I've indicated, as was really telling us nothing, except that you could have an agreement of all concerned.
Yes, there is the note, though, on page 210, hard copy. I claim that a registered adopted child has a right to succeed to all his foster parents' land, but only if related. If no relationship, then child should get no more than a life interest. In this situation, of course, this is a case where it's the grandchildren, the grandchildren of the common ancestor, the children of the adopted person who is succeeding, because the adopted person, Mataura Iti, as I read it, has died. But your lordship is correct in that the court said, well, these are some lands where we can see there has been agreement by the foster father. We're not sure about the other lands, so we'll leave them aside.
What does it say at the top? It says Doe Court. Court, is it? What is at the top of page 210? Who is speaking? Is it the court or is it something else?
It looks to be the court initially, but then
it turns into someone else.
But we don't know who that someone else is.
No, that's what puzzles me. I mean, anyway, it seems to say 20 Court or Doe Court. Anyway, it may not matter, but.
Yes, certainly the Emma decision is much clearer on such things.
I think, personally, I'm not sure, having read it, this case, how far it got you.
No, I accept it doesn't get us very far.
No. I mean, the Emma decision seems to be your big point.
Yes. And about that, as we say, it's a foundational statement, and we say that it is based on a consideration of evidence. And we rely on this at pages 855 to 856 electronically, 227 through 228 hard copy, where Chief Judge Morgan notes his awareness that direct evidence has been given to the effect that adopted children not of the blood can receive no more than a life interest in lands, but upon examination of the lists of owners of many lands, it is found that such adopted children or their descendants have frequently been entered as owners without restriction. The court did not do this of its own volition, didn't make up this custom, but accepted lists of owners submitted by the families or the connectors. It is also true that adopted children not of the blood have held ariki and other titles, and that their descendants have continued to hold those titles in some of the family lands. Of course, an ariki must hold lands. In the circumstances, the court cannot accept as a statement of the full custom the bare claim that they can receive no more than a life interest. And this is the case that first sets out the maturation requirements. And those are found at 222 through 223.
Where do we start? Last paragraph at 222.
Last paragraph, 222.
Sorry, and
My lord,
electronics.
850 through 851, my Lord. Where, though I don't know that he uses the term maturation, he does talk about the degrees that govern succession. Yes, degrees of recognition of an adoption, and that's at the bottom of 222, physically, 850 electronically.
The suggestion there appears to be that both for native customary adoption, that's adoption of a blood relative, and also for a court order adoption, there had to be this maturation or development. That does, the taking of a child under native custom or the making of a court order are only the first steps. Is that your submission?
So the submission on that, if I understand your Lordship correctly, what we say that refers to is that the fact that a child has been taken under native custom, so just picked up, if you will, and the fact that a court has made a formal order of adoption are only the start of the maturation process. They are, if you will, the gate. Well, actually, the picking up of the child under native custom doesn't really mean anything now because native customs aren't recognised.
Pre-1915?
Yes. But the making of the court order now is the gate that everyone must pass through, and then the adoption is considered to have whether the degrees of adoption have progressed such that maturation has occurred.
So is it a matter of agreement between, well, you don't agree on maturation, is it a matter of agreement between the parties that the Section 465 of the 1915 Act wasn't enacted on the assumption that merely by being a blood relative meant that the very act of taking the child of itself achieved an adoption?
Sorry, my Lord, I'll just...
But what is striking in this passage is that under the native custom before 1915, it wasn't enough for a foster parent to say, I want to adopt, or I am adopting this child. There had to be something further.
Yes.
Yes. What that further thing is a matter of dispute.
Yes, and that's where there is the one that says it is maturation demonstrated by acceptance, and that's our case. The other is that it is unanimity.
They're not inconsistent, are they? I mean, this is a case about maturation. It's not a case, as I understand it, which discusses anywhere whether there is or is not a requirement of unanimity. Now, there's no inherent inconsistency between a rule which says that you don't succeed unless you have been adopted on the basis that the family which has adopted you, the immediate family, accepts that you're going to have the same rights as a blood child. That is perfectly consistent with there being a cumulative obligation, if you want this to be effective, also to get the unanimous consent of everyone else. I mean, they're not natural alternatives.
Not necessarily, no, my Lord. If there was unanimity, that would also meet the criterion of acceptance, say, because everyone has agreed. But we say that it does not have to reach unanimity.
No, but you don't get the latter part of that proposition out of this case, do you? What you get out of this case is that maturation is necessary. You don't get the proposition that nothing else is necessary. Apart
from the fact that in this case there was an objection to the adoption.
Yes.
Well,
but there's no discussion of the point.
Yeah. Sorry, I'll come in later.
There's no discussion of that point. And the point may not have been taken, it may not have arisen on the facts, we just don't know.
As I read it, the objection was held to be by somebody too far removed for the court to properly take into account.
Right. Well, that rather underlines the point that wouldn't have been necessary for them to consider whether there was an additional requirement of unanimity, so that you don't get the exclusion of your opponent's submission out of this case.
That's fine. So I accept that.
Can I ask what you get out of this case? I mean, this has a very colonial flavour, and it doesn't appear to be in any evidence. This appears to be a very distinguished judge speaking from his own understanding, as I see it, of what he's gleaned. Might have been from talking to others. It seems to be, to a large extent, from the minute books, which we don't have. Am I right? And there's no suggestion that his statements at the foot of the first 2 pages or on the last 2 pages are evidence-based.
We submit they are, my lord, because they are
Except
based
insofar
on...
as he's looking at the minute books, which we
Yes.
haven't seen.
No, but
Did anyone produce and analyse the minute books?
in this matter before the board,
No, in this case, I mean, they've never been put before us. Were they put before the parties then? I don't suppose they were. They were just his diligent research.
it looks like it was diligent research because he says no one called any particular evidence. The minute books themselves, of course, are a record of evidence given in each of those hearings. And we submit that...
So we can take it that what he says is correct, can we then? I mean, one of the points made is that it's all very well to have a list of entries in a minute book which includes adopted children, but how do we know that they aren't adopted children where nobody objected or everyone agreed?
We submit that the other cases here do demonstrate that Chief Judge Morgan's understanding of the need for evidence of custom is recognised. We say it's shown by that passage where he says the court doesn't do this of its own volition, it does it based on statements and evidence. Also,
there's a point, isn't there, at which a custom of the jurisdiction in which you're sitting can be the subject of judicial notice. And he may have thought that he got well beyond that point. He doesn't explain.
and that's essentially what we say he did here, was he said, I think at this point, having regard to what's stated in the minute book, I can say this is the custom here. And for the purposes of this case, we say that that has been continued to be taken and accepted as the custom for the 50 years now that have passed since that decision.
But the difficulty is that, as my Lord points out, it doesn't actually grapple with the question what would happen if you didn't consult all the family, or if there were family objectors, because, as he says right at the end, there's no family to consult. The only person who objected was an Ariki, who said, well, we were the original Ariki of the tribe, and this must have been a gift by my ancestor, to which there was the rather attractive answer that there was the ancestor, the recipient, the ancestor of the person seeking to be registered, was a warrior and didn't have to rely on the generosity of the Ariki for his lands. He might have conquered it.
He's likely to have been a Mataiapo then.
Sorry?
He's likely to have been a Mataiapo then, my lord. They were the traditional
warriors.
warriors.
So, I mean, anyway, maybe the later cases deal with it.
Yes, the other point I would make now is that I cannot find any case that says that unanimity is required. Now, I researched that and I stand to be corrected, but we say that the that is not, from what we can tell, a statement from the cases.
It's a statement from the paper, the Ariki papers, isn't it?
Well, it might be worthwhile then, though it's slightly out of order, to actually look at that.
I mean, is there any, just sticking to the case law for a moment, is there any decided case in which the question of unanimity has been considered at all? I mean, if there is, I've missed it in this bundle, but that's perfectly possible.
It's been referred to in the terms of unanimity, but there are certainly cases where an adoption has been recognised, and a non-blood adoption, and succession by non-blood adoption, has been recognised and allowed as a matter of custom in the face of objections.
In the face of objection from a qualified person, because this was a case of an objection from an unqualified person, so the issue wouldn't have arisen. I mean, in the absence of any specific discussion of whether unanimity is required or not, it's a bit difficult to grapple with that issue, which is why the Ariki papers may be a more reliable source of information than these cases.
The logic of the case put against you is that since everyone is a co-owner, you can't water down co-owners' interests without getting the consent of all of them. That's the logic of it, as I understand it. And I think that what you rely on is, in this case, the reference to a final recognition by the foster parent and his near family, which is, I mean, a watering down of the logic of the co-ownership, but perhaps an understandable watering down, you would say.
Well, we would, because the near family generally are those who would succeed otherwise. It would, if there is no issue, it would go back up and then to the siblings.
I mean, by near family, we saw in one of the cases a suggestion that you your family was regarded as anyone with a common grandparent or possibly great-grandparents. So if near family is that limited, it may be you don't go to the more remote great-great-grandfather and collateral descendants.
Yes, we don't think one goes back to, if the common ancestor is the person who originally had the land, that could be many generations.
Well, exactly, that's what I was putting to you. I mean, that way it would seem fanciful to suppose you
yes.
Could seek consent from everyone. So there is some, but it's not quite clear what the nature of the restriction is by near family. How would you put it? How would we define near family?
We do think it's those entitled to succeed.
I know, well, that's circular, isn't it?
Yes.
If it's everyone entitled to succeed, then it's all co-owners.
Well,
and how do we define co-owners? Do we define it by reference to going back to the grandfather or great-grandfather only, or what?
I don't think, let's take this case, this present situation as an example. We're talking about where Paddy Browne, who was the respondent's father, where his interests in the lands that he had obtained from his father, Willie Browne, and his father's first wife, Tuvaini Browne. If Paddy Browne left no issue, which would be the case if the adoption did not mature and the respondent couldn't succeed, the lands would have gone to, the Tuvaini lands would have gone to all the children of the first marriage, which is it would be 8 siblings because one other sibling died without issue. And the other lands would go to those siblings as well as the lands from the second marriage. And we say the acceptance by the respondent, the acceptance of the maturation of the adoption by those respondents has been done, by those persons has occurred.
Yes, I mean, are you going to come on at a later stage of your submissions to the evidence for that? Because it certainly doesn't seem to have occurred at the time of the adoption.
No, it occurred subsequently.
Yeah.
Yes. And that, as we submit, the way it usually occurs is a maturation over the course of time. I might then turn to the Tanuraina case, which is electronically at 876 and hard copy at tab 27, page 246.
Tanuraina.
Yes.
That's the name of the deceased, isn't it?
Yes, it is. So then we Tanuraina.
That's page 246 in the hard copy.
Yes. Now, in this situation, it concerns the succession by the children of Marita, who was not related by blood to Tanuraina, and we see that on page 246 or 876 electronically at C. The bulk of the decision then affirms the Emma principles, and we face a claim that there should have been no succession because the adoptee was not of the blood.
And who was making that objection? It was the chief, wasn't it?
No, it was blood family, my lord.
It was Makiainui Ariki, according to page 246. Who was he?
No, that's talking about the Emma case.
Oh, you're quite right, yes.
Not referring to this
Yes,
case.
yes, yes.
The reason I say it's blood family is most simply demonstrated, I think, on page 252 in hard copy, and that's 882 electronically, summarising the submissions from Mr. Clark for the objectors at 6. Where he notes that this was the first time a succession application has been lodged in these, and so the first time the blood family can object.
Well, the objectors were the other two children, weren't they? Mm. The blood adoptees.
Yes, yes. And in that, the learned judge considered not only the views of the adopting father, which was clearly that he stated there was no evidence, this is the bottom of 252, 882, no evidence to suggest that Tanuraina up until his death intended the 3 adopted children to be treated differentially in any way whatsoever. And then the judge went on to consider, of course, the recognition of the near family, the acceptance of the near family, and found, and that's at page 253, or 883, and finds that there was recognition. And then at the bottom of 253 onto 254, goes on to consider whether if an adopted child receives final recognition both from the adopting parent and the near family, can that recognition be later revoked by a subsequent generation of the near family? And the judge notes there's no evidence presented to him that that is recognised custom. And though he says that's what he sees as happening to this case, the children of the blood adoptees were objecting to the succession of the children of the non-blood adoptees, even though there'd be no suggestion, indeed he found there was acceptance by the parents. And it says, can it now be suggested this present generation objectors, many generations after the initial near family, have the right to reject marita when their forefathers accepted her? I do not think so. And that's analogous to what's happening in this case we submit. There was no challenge to the respondent's succession or the respondent's maturation of adoption during the lifetime of the deceased. The objection has solely come afterwards. We agree that custom does not allow that. So that's a case where unanimity was not required.
Was it considered?
Not in those terms. As I say, I can't find a case where unanimity is considered in those terms, which in some ways we submit says that unanimity is not a requirement of custom, because no one has said it is. And I will address the paper's argument on that point. In a moment. In summary, my point on that, though, is the section that your lordships and ladyship are taken to in the papers is actually a recommendation for a change in the law. It is not a statement of what custom was. Because according to the papers, the only adoption at custom was, only succession through adoption was if it was a blood adoption. And they made a recommendation that the law allow non-blood adoption if there was unanimity. But that's not what. They don't say that that's what custom required. The Ripawari'i decision that my learned friends have taken you to is yet again another affirmation of the Emma principles.
Which tab is that?
That's at tab 28, my lord, page 886, electronically.
Yeah.
And this is at page 260 in hard copy, and that will be 291.
891.
Sorry, 891. It is noted that though the need for adoption to develop in the manner we have discussed, that's referring to the Emma maturation, though this is the case where the Court of Appeal says they prefer the term development, nothing turns on that. Before giving right of succession to native land was widely, if not universally, accepted, it does appear that what was seen as sufficient to meet the test could vary somewhat from time to time and locality to locality. Custom is never immutable in all its aspects. And in that case, the statement was that, well, there has not been sufficient, the argument accepted was there had not been sufficient maturation because the adopted child had actually not stayed with the adopting family that long at all. He'd actually returned back to live with his, or remained rather, with his mother in New Zealand. Contrast that with the present case, of course, where the respondent has always lived on the Browne family lands, bar for a small period of time when he was training to be a police officer in New Zealand. In Short and Whittaker, that decision considered the papers, but we submit it's not of much assistance in this case, because that was the decision that concerned whether or not an adopted child could also succeed to natural parents' lands. My learned friend referred to the concern about triple dipping or even quadruple dipping. Short and Whittaker is a very clear statement that says that's acceptable. Now, that's certainly controversial, but that is, if I put it this way, that's not for your ladyship and lordships to make a change to the law on that, especially in a situation where Parliament of the Cook Islands has refused to make a law change in respect to it. And that the fact that the Short and Whittaker case does not impact on the Emma principles is recognised in the Court of Appeal's decision in Tiaraki and Strickland, which in many ways was this case, or a similar argument being run there as is run in this case, about whether non-blood adoptees can succeed. And the Court of Appeal said, yes, they can, in accordance with the Emma principles. It was, in fact, dealing with the exact same lands that were relevant in Emma. Those lands have been the subject of significant challenge. I understand, actually, some of the descendants of the Emma line are also on some of the lands that are here. And just on that, it is not necessarily the case that all owners of the land will be related to each other, because ownership of blocks of land was determined largely by Chief Judge Gudgeon, Colonel Gudgeon, and it was often done on the basis of occupation, at the time. So you will have situations where people who own the same land do not have a blood relationship to each other. So throughout that line
that was because of presumably inaccuracies in Colonel Gudgeon's or Chief Judge Gudgeon's evaluation of the situation. I mean, it wasn't intended, in other words.
That's probably correct, my Lord. But of course, it's unlikely that will now be tipped, though it could potentially be done so under Section 390A of the Cook Islands Act. We say throughout that long line of authority that refers to maturation as a test, that allows succession by non-blood adoptees, that line, we say, does not require unanimity because adoptions have been ordered in the face of objections by other people, by blood relations. And we do not find in there any statement that unanimity is required. And we also say that authority is consistent with other older evidence, being first the Moss letter that the Lordships have heard about.
What is that?
Sorry, that is at page 943 electronically, volume 1 of the blue volume, tab 31, page 308, sorry, of the purple.
purple.
It's at least that's where an extract of it is found. We don't have the actual letter. It's extracted in
Where's the extract?
Short and Whitaker at page 308, tab 31, page 943.
Yeah.
And it notes that there is usually marked by a feast, but of course we don't have that anymore. It says that the child adopted must belong to kindred families in order to enter at once into the family, so that's a blood relationship. If from other tribes or people he does not become a member till formally admitted, it says it may at any future time be cast out. Children in this position are known as tamaua, children of the thigh. The other term that's used for non-blood adoptees, your lordships might see, is tamaangai. Angai being the adoption, if you will, the taking of a child, similar to whāngai in New Zealand Māori, indeed, almost exactly the same. There's a suggestion in the Kortenui papers, of course, that non-blood adoption is a foreign import and was unknown at native custom. And we submit that's not correct. Somewhat hard to point to evidence around it here. But what we can see is in Rimoyo, which is at tab 21, page 219, and regrettably, I'm going to have to go to my copy to figure it out. Page 846, electronically. What we see there is that the original adoption giving rise to this case, or to that case, sorry, was an adoption expressed to be according to native custom, but there is no connection, no blood connection between the adoptee and the adopting parents. And that is one that is expressed there to be a non-blood adoption in accordance with native custom. So we say that the claim that native custom never recognised non-blood adoption is not correct. We also say, of course, that the authorities we've referred to are consistent with the 1894 declaration, and that's found in volume 2 of the blue volumes, tab 18, page 260, which I believe would be page 268 electronically. We are under this statement, the owner says the family consists of all the children who have a common ancestor, together with the adopted children and all the descendants who have not entered other tribes.
So what is this document that we're reading?
This is the declaration of the Parliament of the Cook Islands Federation, my Lord.
When?
This is 1896.
1896, yes. Now,
what's the status of a declaration? Is it it's not a law, or is it?
No, it's not a law.
It's evidence of some sort, anyway.
We cannot make laws, they say. We can only say what is now the Maori law and custom. So, yes.
Yes. No, yes, the federal parliament, the Parliament of the Cook Islands Federation was largely...
Parliamentary research paper.
I don't know that I call it that, my lord. That Parliament didn't have the power to make laws because the 1894, the Cook Islands was at that stage a British protectorate. It was a parliament made up largely of Ariki representatives from the southern group of the Cook Islands, so that's Rarotonga, Aitutaki, Palmerston, Moke, Mitiaro. I can go and get my piece of paper that will give me the list of all of them, if that would be of assistance. So in many ways it is similar to the House of Ariki and Kortenui papers, House of Ariki papers more closely. And that's why they put so much weight on it. And we say that, it says that the family consists of all the children who have a common ancestor, together with the adopted children, thus creating a distinction between there and recognising that adopted children not of the blood, because they would have no link to the common ancestor, are still part of the family, and it is the family that have the rights in the land. The Kortenui in its papers, and as did the House of Ariki, amended that to say together with the adopted children of the blood. But we don't know the basis upon which they did that.
But this statement seems to distinguish between ownership and use, and describes the ownership as being that of the tribe, and the use being with the occupying family. And the comment about who the family are, together with the adopted children who would appear not to be those of the common ancestor, as you say, is really a statement about use and occupation, isn't it, rather than ownership? And that's how it reads. I may have misread it, but that's how it comes across.
Yes, partly by the tribe. I think that's a reference to the idea that the land is actually held fundamentally by the Ariki or the Mataiapo, and it's almost at his or her post the missionary arrival beneficence to allow people on the land. Now that has not been...
It's not beneficence really, is it? It's a title intended for collective use. As I understand it, the use is a matter of right, not of largesse.
Yes, certainly on the family lands, yes.
Not the tribal level.
But it comes originally from, I think this is a claim that it comes originally from the Ariki who gives it to or the Mataiapo who gives it to the family.
So the family is all the descendants of the person to whom he originally gave it, however many generations ago that was.
Yes, yes. And that, we say, reading that, includes adopted children not of the blood. And so...
And presuming descendants enter other tribes by what, marriage and adoption?
Yes, they would be the two ways in which someone would go between a tribe. I need to check with my learned sister whether it could occur by exile as well, but usually if one's exiled, exiles usually don't go and join another tribe.
They just go.
Yes, they usually have to head up into the mountains, say in Rarotonga, where no one goes, apart from nowadays hikers. There was a suggestion by my learned friends that declaration was prepared by Mr. Moss, the British resident. I respectfully can't see any support for that. It's cited to a passage in Short and Whitaker, but I don't see that as providing support for that. It does appear to be a statement by those who say they are making it, members of the Federal Parliament. Sorry, the Parliament of the Cook Islands Federation. So throughout that, we say we have not seen any evidence of unanimity being required at custom. So let's look at where my learned friends say that is found, and that is in the Kortenui report, which is in the blue volume, volume 2, starting page 276, tab 20, starting page 276, which will be 284 electronically, and the relevant passage at page 280 in hard copy 288 electronically. We submit that when one reads that part 4, what it is actually saying is the Kortenui says that as a matter of custom, there must be a blood relationship in order to adopt. In order to succeed. However, the Kortenui says we've got this other form of adoption not of the blood, and we think the law should be changed to enable those persons to succeed. And we say, highlight the following passages that I say illustrate that. First, halfway down the paragraph under child adoption. It says, however, the Kortenui recognises the two types of adoption, but is bound to accept only the adoption according to the indigenous custom as the only adoption that carries with it the right to succession to any traditional titles and to rights of occupation and use of land. So that's their statement as to custom. And as we see, that's contrary.
Well, we have to go on to the next paragraph, don't we?
Yes.
Which is a qualification. However, although that's what custom says, the law has a larger view.
Yes. They say, actually, we think the law should be changed. It says this. The Kortenui proposes that the law be changed to allow the descendants of the common ancestor to decide what right the child adopted, other than in accordance with the indigenous custom, should have. And it's then that's reflected in comment B, which is the proposal, the recommendation, to allow descendants of the common ancestors to approve. Now, it's not clear even from there that this requires unanimity. Again,
presumably if this proposal had been adopted, the legislation would have specified, as the leasing provisions did.
Yes. Whether it required unanimity or whether it simply required a majority of owners under the Land Facilitation of Dealings Act. And I might illustrate for the board that actually the majority of matters to do with Cook Islands law can actually be undertaken by the majority of owners at an assembled meeting. It doesn't require unanimity. So we say custom does not actually support a requirement for unanimity. We say that what custom shows is through the cases that maturation must be there, and we say that custom cannot say it requires unanimity. The custom revealed through the case law cannot require unanimity, because if it did, you wouldn't be able to succeed in the face of an objection by a blood relative. And
although one can't point to any particular case where an objection by a blood relative was overridden?
I thought I pointed to Puare'i. No, Tanuraina is a good one.
Tab 28. Let's just have a look at that.
The problem with that was that it was a claim by the descendants of the adopted person, wasn't it? And the situation appeared to be that the adopted person had been accepted at the time, both by the adoptive parents and by the family. And it was later generations that were coming along and saying, no, we don't agree with all of that.
Yes, my lady, and that's the same situation we have
But
here.
the adoption, the succession was refused. So
Sorry,
No, we're talking about
Tanuraina.
I'm sorry about that. Which
Sorry,
tab's that?
I put you wrong. Tab
876, you could find it. No, sorry, you're not looking at it electronically.
Around 27, I think it's the...
yes, 27.
I mean, that is a case in which the succession is allowed in the face of opposition from the blood relative co-owners.
But they had originally agreed.
But it appears that it had originally been agreed by a previous generation, so we must make of it what we will.
Well, and it's the previously agreed, it's not clear. We say the agreement is through the acceptance demonstrated by evidence of maturation. It's very rare that one would find a statement saying, we agree that so-and-so will will now succeed to his father, his adopted father. But we say we do have some evidence that supports that.
Can I just ask one on the Kutu Nui report you were referring to? What does it mean when they say it's forced by law to accept also the adoption according to the law of the country? I mean, on one view, it might be accepting your case. Might not. Might be saying, I mean, what is the law to which they're referring? Are they saying we're forced to accept adoption according to the law of the country, i.e. an adoption of a non-blood adoptee, is as effective as an adoption of a blood-related adoptee?
What I think they're saying, and we are speculating here,
I see, it's pure, I mean,
is I think that what they were saying is they do not accept that a non-blood adoptee could succeed as a matter of custom.
Yeah.
Now, that situation is, of course, contrary to the court's finding that as a matter of custom, a non-blood adoptee could succeed.
Yeah.
So I think they're viewing, well, because they say blood is everything, we don't accept that custom recognised anything other than blood, so anything that does so recognise something other than blood is forced upon us.
That was the interpretation of section 465 that I was putting forward earlier. Yes. And it was suggested that if that was the interpretation and it was frozen in time, that would be adverse to your interest. But 465A says in terms that other forms of adoption don't have this benefit. So it seems to me, if you read the two sections together, it seems that 465 was seeking to give non-customary statutory adoption a status equivalent to customary adoption.
It's difficult to know what other law they're referring to in this first paragraph.
No. Well, I mean, if it's case law, they may be referring to the Emma decision, may they?
No,
No?
I think it's referring to the Act, which allows adoptions of non-blood relatives, but it's a bit confused about what the consequences are.
Yeah, I see.
Or confusing. It's reached 4 o'clock, so it's time for us to adjourn, but we'll look forward to hearing from you further at 10:30 tomorrow.